This is the current federal tax developments for the week of January the 6th, 2025. Current federal tax developments are brought to you by Kaplan Financial Education and by your state Society of CPAs. I'm Ed Zollers, broadcasting this week from here in Phoenix, Arizona. We're going to talk about a number of things that happened here recently this week. Even though we had a New Year's Day in the middle of all this, actually quite a bit went on this week. First, we're going to talk about IRS relief that was granted for using specific identification of digital assets for certain taxpayers that would apply for 2025 only. We know we have that reporting rule that's coming up and is scheduled to go into effect for 2025, meaning in 2026, we'll be getting 1099s. We also have Department of Justice has asked U.S. Supreme Court to essentially stay the stay, or, backdoor means, let's say, or stay the stay of the stay. I guess that's how we're now that deep. This is back with the Corporate Transparency Act again, the Beneficial Ownership Information Report. We now have another appeal seeking to restart the requirement to get those filed. So if you thought we were done and that you were fine until we're sometime in March, when the Fifth Circuit finally hears the expedited appeal, things could happen a little faster. So we've got something to watch now again. We also have IRS is no longer looking to dispute the requirement to comply with the Administrative Procedures Act to add listed transactions to the listed transaction list for 6707 Cap A after the enactment of the basically the AJCA back in 2024. We'll talk about that. There's been a series of cases IRS has lost. They've now essentially thrown in the towel and said, yeah, we're not going to challenge that one anymore, though we still disagree with the holding. But we're not going to challenge it at this point. Okay. We also have the tax court ruled that merely being regulated in a registered historic area does not make a property a certified historic structure for purposes of making a historical facade easement contribution for charitable purposes. We're also going to find a taxpayer that owes tax over $5.3 million diverted from two retirement plans. We'll talk about that case. That case is interesting for a couple of reasons, aside from things that happened in court. One of which was that the taxpayer in question was criminally convicted, and he had his sentence commuted to what's essentially time served so far by the outgoing president. That's the thing outgoing presidents tend to do these days, is issue a bunch of pardons and commutations. But we also had some real interesting testimony from this guy back when the particular problem that he got convicted of was going on. Testimony before Congress about the need for fiduciaries of retirement plans to be more carefully scrutinized to prevent, the participants from being cheated. So it was kind of interesting testimony and things that go on at that point that was actually noted by the court in the decision as well. So it's a real interesting case for a lot of reasons, but the result probably not surprising, that if you divert $5.3 million from a retirement plan for your own benefit, you're likely to pay tax on it. Think that probably didn't surprise most anybody. Let's talk about now IRS Revenue Procedure 2025-7 that came out on December the 31st, New Year's Eve, right? Last chance for there. Now, as I think I mentioned in the past, these are 2025 revenue procedures because even though they were issued in 24, they will actually appeal. They will first appear in the cumulative bulletin, basically the IRS, I should say, the Internal Revenue Bulletin, I should say, in the first edition that comes out in 2025. So while they're announced initially and actually take effect on announcement, they're actually dated by when they would appear in the Internal Revenue Bulletin, which is their official publication. Now, Regulation 1.1012-1J provides information about cost flow assumptions for digital assets that are sold by a taxpayer. And these apply to all acquisitions and dispositions of digital assets that take place on or after January 1st of 2025. Congress enacted this law a couple of years back. It's beginning now to come forward and will take effect in theory in 25, although this week, tax analyst in Tax Notes Today Federal did have a report that the income administration may be looking at pushing this back again. So keep that in mind. For the moment, it's scheduled to go forward as we have it at this point. Now, different rules for identification apply if your digital assets are held by a broker versus one you're holding in your own wallet, right? So if you have an external wallet that you're keeping it in, there are different rules than if you have these on deposit with a broker like Coinbase. There'll be different sets of rules, just like there are different sets of rules for when we have stock that's, being held by a broker versus if you actually are holding the shares yourself. Now, for a brokerage held digital asset, the regulations say a taxpayer can essentially specify to the broker the particular units that are to be sold by an identifier, such as a purchase date and time or purchase price, no later than the date and time of the transaction itself. So essentially, you do that. Now, the broker essentially sets up, in this case, a designated identifier system. And they will set up what they will take as sufficiently specific in their system, and you'll just have to execute and do that, on or before the date and time you actually sell the digital asset in question. It's not one of those things you can wait till you're in and then decide, well, I'd like to have capital gains, or would I really, really like to, kind of reduce those down this year. Nah, can't do that. Just like with stocks, that wouldn't be allowed. You're not going to be given that option. And if the broker designated identifier is not provided on a timely basis, then, just like we saw with stocks, there's going to be a first in, first out assumption for how things are going to work. Okay. Now, some brokers have informed the IRS that they're not going to have the technology available to make specific IDs requiring this reg as of the beginning of 2025. So, because if you went and you sold some of your digital assets, here in 2025, let's say you sold some on Friday of last week, that you had to identify under these rules prior to this relief, or we're going to have a problem. So now they, on December 31st, issued the relief issues. So for 2025 only, from January 1st, 2025 to December 31st of 2025, you can identify units held in custody of a broker by either identifying specific assets by referencing identifiers such as purchase date and time or purchase price no later than the date or time of the transaction. You don't need to have the brokerage tell you how you have to make the ID. Or you can record a standing order on your books and records with sufficient detail to identify the units so long as it was entered before the units were sold. Those are your two options this year. In essence, and they're pretty very, very similar, shall we say, the options you would have in the brokerage, except, of course, you're doing it now and informing the brokerage before the sale that, you've done one of these two things, and this is how you're identifying the assets in question, because we want to make sure we get our, normally you want to take high basis assets. Is usually why we're doing this, to try to get our high basis asset out of this. Now, the one method rule that applies when a broker only offers one method specific ID that is treated as having a standing order does not apply while this revenue procedure methods are used. So, if they have some way to do it, you're not really stuck with that, in essence, at this case. Traditionally, beginning next year in 2026, if they have only one way to ID, that is considered to be a standing order, right? They can say, we're always going to do it this way. So for this year, you're allowed not to do that. I think the concern was, and probably some brokers just use the standing order method as whatever their system was doing now, they're just going to force everybody to do that, because they didn't want to spend the time to reprogram. So in theory, this may open that up for the year, right? Now, this relief does not apply to units that are not held in the custody of the broker. There you look at rules for held in your wallet. Those continue to apply. Nothing's unusual, nothing's different. That's found in Treasury Reg 1.1012-1J1 and 2 provide information on that. And this does not create a method of accounting under 446 or 481. In fact, the regs tell you generally the idea method you use is not a method of accounting situation. As you should be aware, if it was considered a method of accounting, then you would need IRS permission to change it. And the 3115s, and we'd have catch up and all kinds of other things we'd have to do. So good news is this is not an accounting method for these purposes. And this relief is a temporary workaround that allows taxpayers to use their own books and records, basically, or standing orders, identifiers, whatever, to identify digital assets when determining basis. even if their broker is not up to speed. Now, obviously, your broker is up to speed. You obviously could use their methods now, because that would kind of, by definition, you'd be identifying it in a manner that was good enough for the for the broker to identify it. So that's the key here for this revenue procedure. Just get some options in this case. Next up, our never-ending story continues. Back to the Beneficial Ownership Information Report to the Corporate Transparency Act. This document was an application for a stay of the injunction issued by the United States District Court for the Eastern District of Texas. This was in the U.S. Supreme Court. Texas Top Cop Shop Inc. versus Garland. This was filed as well on December 31st. In fact, I think it showed up about 5 p.m. Eastern Time. On December 31st, this was filed by the government, right, with the U.S. Supreme Court. Now, it's Justice Alito, I should say, who is the one that's in charge, as I recall, the Fifth Circuit. So he's the one it was given to for this particular motion. Now, the Supreme Court could do nothing about this. They could ignore it. They could pick it up. They could hear, information, etc. There are various things they can do, right? Generally, we'll see whether, in fact, they want to take action, if they want to do something, because DOJ gave them a few options here as to what they could do. And I think one of them is one they're thinking they'll bite on, even if they don't want to do the bigger issue to start with. So we'll go with that. Now, they're arguing that what they want to do is remember, let's review where we were. We had a court in Texas, district court, that in essence issued an injunction blocking enforcement of the Corporate Transparency Act's Beneficial Ownership Information Reports. The Department of Justice asked for, in essence, emergency relief. And the motions panel of the Fifth Circuit Court of Appeals granted that, in essence, they put a stay on the injunction. So we were back to having to file the reports. And while we were in that situation, which turned out to be not for very long, the FinCEN posted a notice that said essentially they were going to allow us until January 13th to file the reports. After that, the merits panel, the panel that's going to hear the merits, this appeal on the merits, they issued another order, this time staying the stay. So in essence, reinstating the injunction that was nationwide, pending the actual appeal being heard. Okay. They had said that was to maintain the status quo in the interim while we were considering these serious constitutional arguments. Now, Department of Justice has now gone one step higher, which is where I figured they were going to go, and they did. So now they're asking the Supreme Court to step in and saying, court, step in and at the very least, in essence, pull the injunction, get us back to where we were with the motions panel position. But maybe you just want to kind of take the whole thing on too. We'll talk about a couple of options there. Now, the DOJ says the presumption acts of Congress should stay in effect pending Supreme Court review. They point out that historically, what's happened if courts have issued these orders is they've been stayed, and we just keep them in effect until the Supreme Court hears it, because the Supreme Court generally hears cases if a federal court has said a statute is invalid because it violates the Constitution. Those cases are almost invariably heard by the U.S. Supreme Court to finally decide the issue, right? They said, basically, as they note this, they look, based on the history, it's very likely, guys, that you're going to hear this case, right? Yeah, you nine, you're likely going to hear this case. We know that. So, really, we should just strike this down. You're the party that's going to decide this. It's not going to be a district court in Texas. It's not going to be the Fifth Circuit Court of Appeals. It's going to be you. You nine are going to do this. So really, we shouldn't allow any actions to take place till you nine have heard and ruled on it. Shouldn't allow these orders to, block this. And generally, we don't sit around and wait for somebody to maybe complain about a congressional law being unconstitutional. So generally, we presume they're constitutional until such time as you guys finally order and say, hey, yeah, this law is not constitutional. So, it's blocked and doesn't go forward. Okay. Now, they also argue that they are likely to succeed on the merits. Now, this is the arguments they made all before. So again, this is a restart of the standard reasons why they should be granted it. They make the argument that the CTA regulates economic activity, so it is within Congress's Commerce Clause powers. Now, that's the argument they've successfully won on in 2 circuits, and have lost on into not 2 circuits, but two district court cases, and have lost on 2 district court cases, right? So we have this kind of up in the air. Now, the reporting requirements involved with this are necessary and proper to dissuade individuals from using companies for illegal purposes. They're saying that this is well within the federal government's essentially police powers, to dissuade illegal activity by, opening up the ownership of these entities so that law enforcement can basically follow the money. Kind of the bottom line. They said that the plaintiffs, the respondents in this case, because, the DOJ is the one asking for this relief, and so the other party is the respondent when you read the notices, right, have not met the highest standard to bring a facial challenge on the suit. And you've seen that argument also come within whether it is a facial challenge, whether the challenge should be for the law as a whole, or whether a particular plaintiff has to show that it would be illegal as applied to them. That gets into a back and forth discussion that especially the Texas court spent a lot of time on. They also say the equity favors a stay based on due to harm to the federal government. It prevents execution of a duly enacted act of Congress. They're going to lean heavily on the fact, that the presumption is Congress acts legally. That the court should not lightly dismiss congressional action. It impedes efforts to combat financial crime and protect national security, meaning that while this stay is in effect, we can't find out these ownership items easily, and that means that crimes and various other things could be carried on in the interim, right? That could either have financial crimes being carried out or items that affect national security. And obviously the thing they will mention here is terrorist activities, funding being hidden behind that. So we're going to say these are both being impeded by this. And it severely disrupts the ongoing implementation of the CTA, adding a lot of confusion to the situation with this on again, off again. And notes that it only imposes a minimal burden on the plaintiffs, repeating their argument that, it was probably $80, $85 per entity when you consider the value of the time involved in doing it. I should add at this point, in case somebody is listening to this going, no, I went online and I have to pay like $500 to do this. No, don't click the first thing to be returned if you do a search in a search engine for filing the CTA or BOI reports. Skip the ones that say sponsored. There are a lot of groups out there that are telling people, or mailers do the same thing, by the way. We're seeing it that way. That, oh, no, here it is. It looks like an official form, and they want like $500 or more to do it, whatever the number might be. Yeah, that's technically no. If you're being asked to pay money, you're not on the CTA site. You're not on the official site, the official place where it's filed. Now, there's nothing wrong with paying somebody to do this form, right? I have had clients pay me to help them handle this form. But you should at least be aware that you're not required to do that. And I've had clients successfully file it on their own. It's just that's kind of how this goes. So just a warning in case somebody there is thinking, that's a lie, man. I had to pay $500. You got taken. Unless you knew you were paying somebody and you could have handled it on your own, and whoever was doing it didn't tell you could have just done it, you probably got taken. Just saying. And then I'd be very concerned about my, that detailed confidential information is handed to somebody that was willing to mislead you this much. You got to wonder if they have other ways to make money off of it, which you might not be so thrilled about. And we're not talking about simply selling you ads, guys. We're talking about doing a whole lot worse. Okay. Now, This is the one I think they're hoping gets their attention. They're saying this court's injunction is overbroad. The district court should never issue a blanket nationwide injunction invalidating a law. They should limit it to the plaintiffs in front of them. They are a court of equity. Okay, a court of equity is only limited to equitable solutions to the problems for the party before it. Now, this is one that may attract their attention because, again, there is some concerns. You're going to have 600 U.S. District Court judges. If you're allowed to let every one of them strike down any law they dislike, that could be very disruptive. It doesn't matter which administration's in office, right? It could disrupt the heck out of anything. Congress passes a law. I just need to find that one judge of the 600 that doesn't like it, and thinks it's overbroad and violates the Constitution. Get my case in front of that judge, and voila, the law is knocked down and thrown out of commission. And in theory, could be sitting out of commission for quite a while. That could complicate a lot of things. By the way, there's a flip side there too. People, don't get too transactional on this case. A lot of people think purely transactionally when we're talking about political cases. What do I believe politically? Which is fine. But the courts tend to go broader, more conceptual in their views. And the problem is, yes, if the court can knock it down, it can knock down every law. And if a court can't knock it down, it can't knock down any law. And you're probably going to dislike some results either way. I'm just going to tell you about that ahead of time. Keep that in mind. Don't get transactional here. This is a separate argument from whether or not, the law itself is valid. This is going back to the argument that the Supreme Court should be the party to decide that, not, every one of the 600 judges across the country getting their own whack at it. Because all you need is one to say it should be it's unconstitutional, and suddenly you get this, bar across the country, even if 599 have said it's fine. So, they're going to kind of lean into that, right? A court of equity, as I note, the argument is can only grant relief to parties before it. This is being granted to parties that have never said a word about this, right? We're just going to grant this there. The court lacked the power to do this. They're saying district courts need to be told clearly that they don't have the power to do these nationwide injunctions. Only they could protect the defendant, meaning they're saying the court in Alabama. Now, DOJ still thinks they got to the wrong decision, but they acted within their powers, right? The court in Alabama acted within its powers. It only granted relief to the parties before it. They're saying the court in Texas went beyond its powers, usurped the powers of Congress and the Supreme Court, you might argue, by issuing this nationwide ban. So they're saying, you guys want to rein people in. You've never had a good case to do it. They're offering this case up as a great case to do it in. They said the order itself disrupts the status quo to its last minute filing. That is giving, lip service to why they're saying that the merits panel is wrong. This is not preserving the status quo. If in fact there were major concerns about this thing being wildly unconstitutional and having these huge constitutional problems, why in the world did the case only get brought up late in the game? Basically it seems like something that serious should have come up much earlier. When it could have been blocked. If the parties that concerned about it should have tried to block it earlier, right? And then it would have been able to get all the way to the Supreme Court well in time before the law came into effect. Right? So they're saying the universal injunction problem, in addition to the specific case, this is your opportunity to deal with it overall. In essence, this is a perfect case to let the Supreme Court address the term they use as the lawlessness of universal relief. Okay? They noted that the court has not had a case before. They've either, the court has not had a case before because of how things have been presented to them to actually rule on whether a district court has a right to do this. There certainly has been a lot of discussions and basically by a lot of different justices of different persuasions that have certainly suggested that they don't believe district courts should have this right, that this is improper for a district court to do this. And they're just saying, look, you guys could all get together now. You kind of all agree on this. You guys could all get together and use this as a case to tell the district court, to keep their hands out of this area, right? Just, you can grant, if anybody sues in front of you, fine, grant it for them. But don't worry about it if they, if you don't have a, any party not in front of you. Just let the case go all the way up to the U.S. Supreme Court. If the U.S. Supreme Court decides, let's say, in the case involving, Texas Top Cop Shop, if they decide that this law is unconstitutional, it's unconstitutional in a way that it's facially unconstitutional, then the Supreme Court, by having said that, will tell you it doesn't matter how many plaintiffs come in, they're all going to get this decision. So the Supreme Court will be able to strike it down overall, right? They're saying this is the perfect case. If you want to treat this as a request, right? Request to grant cert on that issue for this case. We're all for it, guys. Just do it and open it up. Now, Justice Alito, which I said is the one in charge of this for the moment, he basically has notified the plaintiffs that a response is due by 4 p.m. on this coming Friday, January 10th. We would expect if Supreme Court is going to act on this, I would expect them to act relatively quickly. This is not something, they kind of understand that we don't, there's little point in letting this thing hang around for an extended period of time if they're not going to step up and do anything. Otherwise, let the March 31st, let the March, basically, I should say, let the sometime in March hearing, get the date right now, go forward, and let the Fifth Circuit deal with it if you're just going to, dawdle along and pick it up eventually. So we'll see what they step up and do. And I do think this particular last argument, this invitation to knock down the district courts from, slapping down any law Congress might pass, in the future, that could prove tempting to the courts because they've been more a little disgusted with what's been clearly, I'll just say it's been, they've been shopping for a forum. They've been shopping for the right judge. It's been kind of obvious sometimes what they were doing because there are certain cases in certain districts, certain courts, you find a specific court, in their division of that district court that you can pretty much guaranteed to get one judge. And if you know that judge's leanings on a case like this, then you want your case in front of there. You're going to try to find some way to get the case filed there. And that's, of course, what they're alleging is happening. On the other side of the equation, government throwing in the towel, we have action on decision of 2024-01. It took a while in 2024 to get one of these, right? But on December 23rd, they issued this AOD. And it addressed the validity of listing notices issued without following the Administrative Procedures Act and putting them on the listed transaction list without following the notice and comment rulemaking procedures. And that's specifically the ones that were added after the Americans Jobs Creation Act of 2024. Now, if you remember, that added the really harsh penalties for not disclosing you were involved in a illicit transaction. And also provided the IRS could add to the list. Now, why that's interesting is because up until this came in, the ACA came between the AJCA came in, the IRS had been just putting them on the list by essentially, issuing notices, and Congress was aware of that fact. That's how it had been done. So, the IRS just kept issuing notices. They're saying, well, they're fine with how we're doing it before. We're just going to keep doing it. In the past couple of years, that's been challenged, saying that the American Jobs Creation Act, at the very minimum, the AJCA changed the situation pretty drastically by imposing massive penalties and other problems. It became much more important it was a listed transaction. And so in 3 separate cases, the IRS has faced and lost challenges regarding whether APA procedures had to be followed to add the listed transactions list, following the enactment of the American Job Creation Act of 2004. And those cases were, first up, the case of Green Rock LLC versus IRS, or I should say first up, that was heard this year. It was the first case that went through the lower courts. The 11th Circuit heard it and on appeal, ruled the same thing this past year. We also had Mann Construction versus United States. The 6th Circuit heard that one in 2022. And we had Green Valley Investors LLC versus Commissioner, which was a public tax court decision in 2022. Okay, with the most recent, with the Green Rock 11th Circuit decision, the IRS has decided, even though they disagree with these holdings, I said we still disagree with the holdings, but they have decided that they are going to throw in the towel on this one. What all these cases said was that for the IRS to add anything to the listed transaction list, they had to file a notice of proposed rulemaking, publish that to notice of people that are thinking of doing it, and then give the public a chance to comment on what they're going to do. So effectively run it as a regulation. So you'd have a proposed regulation, public comment, hearing, and then issuance as a final regulation. And that is what the IRS is going to be doing going forward. They've already done some of these adding things back to the listed transaction list by going down this route, and they're going to continue to do that. Okay. So what we have here is, legislative rules. They ruled they were legislative rules as to create new substantive duties, the violation of which can lead to financial penalties and criminal sanctions. They're saying that was a sea change once that happened. And the Administrative Procedures Act says you have to, unless clearly authorized by Congress, to skip the APA, which all the courts so far have said you are not clearly allowed to skip the APA by what Congress passed back in 2004. So you have to do this, the structure of having basically the whole notice of proposed rulemaking, your proposed regulation being issued at the same time. That's how you issue that. And then open up for public comment, determine if you're going to hold announce at least a hearing. If anybody wants to speak at it, that'll take it, or whether they'll just do written comments. Most time it ends up being just written comments. And then following that, you can then take it final after taking into account the comments. Okay, well, like I said, numerous causes have now convinced the IRS that, yeah, we have substantial controlling precedent. The tax court will always rule against them in this case. Will always get it thrown out there. And they know the 6th Circuit and the 11th Circuit have ruled against them. They don't have a win yet. It appears they're going to lose almost all cases unless they find a district court, unless the taxpayers dumb enough to take them to district court, or they find another circuit. So, hoping one of the other circuits will agree with their position, which at this point they're deciding it's probably better to cut your losses and just, go back and do it the other way. So what they announced is they will no longer enforce post AJCA additions that did not follow the notice and comment procedures. As already noted, they've already done some of those that actually follow those procedures. They've reissued some. And so after it's been reissued as a final regulation, which a few of them have now, then they'll go ahead and keep doing like they've done before. It'll be a listed transaction, right? Now you got to challenge an actual standing reg, which is a little bit higher burden to go. You've got to do more than simply say you didn't dot your I's and cross your T's by doing the APA requirements. And they'll not assert any penalties on those listed transactions and will concede them in any ongoing cases before the courts. So if everything has already been, they already issued the 90-day letter, you've gone ahead and filed in court for it, or you paid the tax and then you filed for claim for refund, were denied, and now you're going to court. If we're already if we're already got a case where, the case is before the courts, the IRS is going to basically concede the penalties on the listed transaction and, and get rid of that. They're not going to assert them. If they have an exam right now, they're going to drop that assertion. So that's what they have announced they're going to do, right? And they will not assert an extension of the statute of limitations. That's another thing that these listed transaction rules did. Remember, if you don't report a listed transaction, then the statute of limitations doesn't start to run on that year until you file a disclosure form. They're not going to, assert that, in this point, or the exception to the suspension of interest rules that also apply if the service doesn't move quickly enough on the issue. They're going to go ahead and say, okay, we're not going to assert that any of those bad things happen because we'll go ahead and we're going to accept for now that this is not a listed transaction. And because of that, none of those penalties, et cetera, can apply. And none of those sanctions can apply. We're going to be pretty straightforward. Here's what we do. Now, they did say, be very careful, though. The AOD does not apply to any basically listed transactions that existed at the time, the ACJ was enacted. They're saying Congress knew about those, Congress accepted those. So we're not going to concede those don't count. So you got to check, going back to, if you have a list of transaction that was there in 2000, that was there, before this thing got passed, I think it was toward the middle of 2004, if I remember right, that we got this passed and signed into law. If it didn't exist then, if it was already on the books then, we're still going to go after the penalties. We're still going to go after the, statute of limitation extension. We're still going to go after all the negative things at that point, because we're going to say Congress essentially ratified those. So we're going to go ahead and accept that. Okay. And the IRS is in the process of issuing new regulations to put these transactions back on the list. So the ones that currently exist and just got struck down by this, effectively taken off by this, what they're going to say is, we're now going to go through the process simply proposing regulations, taking comments, and finalizing the regs. And it goes like the last couple have. Don't be surprised, don't make many changes before they finalize the reg. So just be aware of that. Okay, next up is a case, Capital Places 2 Owner, LLC versus Commissioner. And this is a published tax court decision. It was 164 TC number 1, issued on the first day that it could be issued in 2025, January 2nd, by the court. Now, this is a partnership that claimed donation for a conservation easement for a historic facade on an early 20th century structure that was located in a historic district. And they claimed a charitable contribution of $23,900,000 as a donation. Now, while this property was in the Columbia Commercial Historic District, right, which was listed in the National Register for Historic Places in 2014, the building itself was not specifically listed. It was just inside that historic district. Nevertheless, the taxpayer claimed the deduction. Now, the IRS argued that this building was not a certified historic structure under the requirements of Section 170H4C. There's a definition of what's a certified historic structure, right? They're saying, the first part looks, there are two ways of getting in. The building itself could be individually listed in the register. Regardless of whether it's in a historic district or not, it could be listed in the register. And if it is, then it would qualify. Or secondly, the secretary, if it's in a historic district, then the law requires the Secretary of the Interior to certify the building as being of historical significance in the district. The IRS is saying neither of those had happened, right? In essence, the building itself, was not in the register, and the partnership had never asked Secretary of Interior to specifically certify this building was of historic significance inside the district. Neither of those happened. This can't qualify as a certified historic structure for the credit. Okay. Now, the tax court looked at the statute itself. It was using principles of statutory interpretation, and it noted that a proper interpretation must give effect to every clause and word of the statute and not render any part of the wording superfluous. Basically, and you notice we talked about that a number of times in recent cases. It's becoming more and more, again, especially after Loper Bright, this has become a more significant discussion point the courts are going to spend time on. Right? Now, they rejected the argument that a building merely in the historic district would make it listed. It said, no, the statute requires the building be listed or be identified as historically significant by the Secretary of the Interior. Right? It's not just, it's not like, all of that is, it works together. There's no reason for that certified by the Secretary of the Interior as being historically significant if, in fact, it doesn't matter. Every building in the historic district would be done. It's kind of, it'd be a bit of ridiculous, right? So the taxpayer's argument renders that identification requirement superfluous. In essence, why is that language even there if every building in the district would automatically qualify? You wouldn't need the Secretary of the Interior to do it. So it did not otherwise qualify for a conservation purpose under IRC 170H4A IV to preserve a historically important land area. They hadn't shown that was involved there in their structure. And That's basically the background here in this case. Now, why this case is important is because this is the first time they've actually dealt with this particular issue. Does a property need to be listed? What exactly, can you argue merely we're in a historic district? No, the court is saying very clearly no. This requires, before the contribution is done, that either the building be in the register itself, or that that in essence the Secretary of Interior makes a specific designation that this building in a historic district is historically significant. With neither of the others done, it doesn't matter. You cannot simply argue it's in a historic district, and that by itself makes it a qualify for this sort of basically the deduction for contributions of the conservation easement, which is one of the few ways you can get a deduction when you give a partial interest. Okay. Finally, we have an interesting case here. This is Hutchison versus Commissioner. That's a random decision 2025-1, also issued January 2nd. And this is a fiduciary of a multi-employer retirement plan. He was trustee and fiduciary of a multi-employer retirement plan in Idaho. He held himself out as an expert in fiduciary matters, and he testified before a congressional subcommittee. And his testimony literally was about, the need to carefully, supervise and control and put standards in for fiduciaries of plans, so they don't do things that would put, the employees' retirement at risk. And he specifically noted that he would never have put money into, Madoff, et cetera. You got to check various things and do this. Now, this is all kind of interesting because, as we're going to discover, he's doing this in the middle of a year that a bunch of transactions take place that eventually gets him a conviction and 17 years in federal custody, which did get cut short a bit. He's got all that in here. So it was a little interesting that he was testifying as well. So that's also kind of fun. Okay. Now, in 2010, he diverted $5,307,688 from the two plans, primarily to pay personal expenses. He was involved, as I said, two multi-employer retirement plans. He diverted them primarily to pay personal expenses. And now we're going to get into kind of what this is. He used the funds to purchase and renovate his own home. Okay. Tough to see a plan there, but okay, we got that plan purpose for those funds. Okay. He paid a number of personal expenses. He bought cars. He bought Christmas presents for the family and friends. He bought furniture. We're not talking about the cheap stuff. And he had he went to Costco and used these funds too. It's like, very, very much down-to-earth gentleman. Yes, he went to Costco and got the stuff all purchased. So, hey, nice, great. He also spent funds on the attempted acquisition of a resort and a golf course. So he's kind of going in. Now, the home was kind of funny because he sold his home and moved to Idaho. And the home he bought was in Idaho, essentially the cost of that home was over twice of what he got for the home he sold. So, and he still needed more funds to basically renovate the home too. It was a real interesting project. And he had a note that he had to get paid off within a year to go find somebody to finance the mortgage, which is what it's kind of reads between the lines. And the incentive to make sure he found somebody was the interest rate went up to what was 125% annual rate. It was phrased as a daily rate. For basically, once he went past that drop dead date, if the loan had not been refinanced, he didn't pay it off, then he was going to be paying an astounding interest rate, right? In essence, you're going to have to pay the interest more than the entire value of the property, right? In the first year following. So time was running out and he didn't have options. So he kind of found money. He saw this money sitting in the retirement plan. He took it. And, now that's not how he phrased it. He actually borrowed it. And he then invested the funds into this note program that would pay a guaranteed 14%, et cetera, et cetera. But the court seems like neither the criminal court nor the tax court's buying that story. That it was just, it's coincidental that he borrowed from that fund. Yeah, they're saying now it was personal use. Nah, we're just going to call it personal use for this purpose. Certainly the jury called it. Not the jury didn't think it was so great. Put it that way. His jury on his criminal case really didn't think it was great, and the tax court judge wasn't really thrilled either, right? So he had that. He then used it for personal expenses, and this is something we find quite a bit with embezzlement. If you do something and it doesn't get caught, you just start doing more. And then he went out, he tried to acquire a golf course and a resort. This one at least had the trappings, you might argue, of, okay, maybe something that the plans might have done, but it's not really clear. The judge's trust in his testimony had gone to zero very quickly in the case, as had appeared the juries and the judge in the criminal case. So, unfortunately, he wasn't going to get the benefit of the doubt that these funds were being used actually, for plan investments, which is what his defense primarily is. Right? Now, he was discovered when certain people began questioning the investments, which were effectively loans to the taxpayer, and he told participants was an investment, right, with a economic development fund, was safe and would return 14%. Later on, he confessed to taking the assets. So he did some deceptions up front, right? He created false documents, right, in this case, right, to cover up his actions. He had irrevocable trust receipts backdated. When he discovered he was under investigation, he created documents to show these supposedly irrevocable trust receipts. That meant, he was on the hook for this stuff. It's like, yeah, they were backdated 2010. That's not good because 2010 was the year he did this. It was all kind of bad, right? And he was convicted on 17 counts of wire fraud and was ordered to spend 17 years in prison, 1 year for each count, apparently. He was ordered to pay restitution of the $5.3 million that he had taken. Okay, bad day all around, right, for him in terms of, criminal case was bad. He's got to pay $5.3 million back. He also had to, he got sentenced to 17 years in prison. No, he didn't spend all 17 years in prison, but he spent a good, he basically got through, I think he was convicted in 2013. So, he spent a number of years there in federal custody. He's out, he's now out. He's now released because he was not pardoned. He just had his sentence commuted. He was not a pardon. It was not a formal pardon. So he just had his sentence commuted to the time served by the president. So yeah, that's where we stand right now. Now the question is, does he need to pay tax on $5.3 million? And you might think, well, wait, he's ordered to pay it back, right? And he claimed all along he planned to pay it back. So, is it really income? Well, if you haven't been down this path before, the answer tends to be, yeah, it's going to be income, right? He had unreported income of the $5.3 million because he embezzled it. He misappropriated the assets, used them as his own, which is treated as income. He essentially had unrestricted control of the funds. Essentially, kind of like Bernie Madoff, if the problems hadn't started rising where it got noticed, well, in Bernie's case, he just knew it was going to be noticed because there was no way he could pay all the calls for the funds. If you remember that's how he came forward. So essentially, basically when he discovered he's being criminally investigated, it was like, well, this is all going to come out. So then suddenly he apparently claimed he was going to pay it back. Right? He also had to pay a minor detail. He took funds from his IRA too early. He wasn't 59 and a half. So yes, he hadn't paid the 10% premature distribution tax. I'm sure he probably claimed, who knows what he claimed about why that didn't work, but he didn't. He also had failure to file penalties. He hadn't filed a return. So, that's probably the reason why he didn't get convicted of tax fraud, right? He hadn't filed a return, so it was tough to prove he had intentionally underpaid taxes. He had never filed the return. And while you might think part of that reason might have been because he knew he would have owed a lot of taxes had he done it properly, an actual return that omitted this number would have been more helpful there. And anyway, you get this whole craziness of embezzlement and whether or not, he believed since he owed the money back anyway, that it really wasn't income. We're just going to say that, yeah, there are reasons why this one would have been tougher to get the tax fraud on. But he was found liable for the 75% fraud penalty. So not only does he owe the tax on the $5.3 million, but he owes the 75% penalty on top of the interest on the tax. Remember, all of this was taken out back in 2010. You're talking about probably close to 3 times or more of the total tax is now due, well in excess probably of the $5.3 million that he embezzled. Yeah, it was kind of bad, shall we say. Bad situation in that case. So he was hit up with the fraud penalty as it was. Now, the court rejected those trust receipts as evidence of investment. Also said the investment in another entity also appeared to be fraudulently put together. There was no evidence anybody except that Mr. Hutchison signed the stock certificates. Nobody else knew about them. It was just like the criminal investigators showed up and suddenly started papering things over. They found he was not a credible witness. Bottom line, he owes tax on the $5.3 million. So anyway, it's kind of interesting to go read his testimony is still online. You can actually go read it. He testified to a subcommittee of the House back in 2010. Was what he testified to on this need to, kind of do all this oversight. It was basically, as I suspect from him talking about Madoff and the like, dealing with investments in Madoffs and other funds that had come apart then. But it's just amusing that it was going on at the same time that he was taking $5.3 million, or at least being a little fast and loose with it. And one of the things which the court also pointed out was, as an ERISA fiduciary, there are definitely court cases on record where, in essence, anytime you misappropriate or take funds out and use them for your own benefit, that's considered embezzlement and that's income. This has been tried before. There's nothing new here in this case. If he does actually repay the funds, then he might get a deduction. If I remember my other case law in this area, the argument is you might get a deduction for that. But as it stands right now, and I'm sure the court believes, there is probably no chance at all he's going to actually be able to repay the $5.3 million. Like, remember, he owes the $5.3 million, plus he owes the tax, plus he owes the fraud penalty, plus he owes the, late filing penalty, plus he owes, the interest. Odds are he's not paying this stuff, right? Remember, he did this because he could, nobody wanted to loan him money for the house. That's what got this started, right? He couldn't get a third-party loan to buy the house. He bought over the top, and then he scrambled like mad to, cover that. And yeah, it just got messy, shall we say. Things got a bit out of control. And again, don't know the whole history here, what's going on and some of the other structure there. But it looks like a rapid collapse based upon him just wildly overreaching, coming to town, taking over, 2 multi-employer plans, and then noticing they had money in them. And no real problem until somebody actually started asking questions. And then suddenly everything fell apart quickly. Well, this has been the current federal tax developments for the week of January in this case, this weekend in January, or the week beginning, get the right thing up, January the 6th, 2025. As always, current federal tax developments are brought to you by Kaplan Financial Education and your state society of CPAs. If you have any questions, you can email me, edzollers@currentfederaltaxdevelopments.com. You can also find me on the Connect sites for Arizona, New Jersey, Idaho, Illinois, Minnesota, Washington. So again, let me know if you see anything of that sort or you post something there. I'll try to take a look and see if I can help with it. Otherwise, hang around, check back in next week. We'll see what's up and going on in the area of current federal tax developments.